Morning, everybody.
Good morning, Judge Richardson.
Good morning, Your Honor.
2 seconds, Judge.
No problem.
I was working on transcripts. Good morning, Council. My name is Octavia. I'll be your court reporter. Do you all want this case taken down for the record?
I would like it taken down, yes.
Okay, thank you, Mr. Davis. Ms.
And-
Council Winthrop, would you like to participate? Or would you like to?
Good morning, Your Honor.
Morning.
2 seconds, Judge. I'm sorry, Mr. Winthrop, I didn't get your answer. Would you like to participate in the takedown of this case? Good morning, Council. My name is Octavia. I'll be your court reporter. Do you all
Hold on
want
a
this case
second.
taken down for the record?
There we go. It's being live streamed in order to make sure that we comply with the open records. And so that there was a little bit of feedback there. Go ahead. Octavia, did you get your response from Mr. Winthrop yet?
I did not. Mr. Winthrop, you're muted still. You need to push your mute button.
Sorry about that. Yes, I would like to participate.
Thank you. Thank you, Judge. I'm ready when you are.
All right. Okay, folks. I know we have the motion for IME that's pending, and there's some other things I know that are thrown in there. I've read your briefs, so let's talk about what needs to happen here and why, and what's been the holdup here. So, Mr. Davis, I'll turn it over to you for that initial response.
Thank you very much, Your Honor. Your Honor is correct. There are, in fact, a few motions pending in order in which they were filed. It was a motion to extend the remaining deadlines, a motion for an IME by Drs. Bowl and Gordon, who are 2 of the 3 defendants' experts. And then there was a follow-up motion to compel an IME by Dr. Richard Restak, who is the defendant's 3rd expert and is a replacement for an expert, Dr. Barbara Long, that the defendants recently lost due to medical issues. So to start in that order, Judge, the reason that we've requested an extension of the deadlines is because Dr. Bowl is withdrawn due to medical issues and forced us to get another expert, which we did on short order. But we feel that we're going to need more time in order to complete expert discovery. In addition, and probably most importantly, are the motions for IMEs. So as you know from the briefs, Your Honor, this is kind of an unusual case, at least for me, in that it's a rather serious allegation of a traumatic of a brain injury. And yet there are no medical records from treating physicians in the case at all. And in fact, the only medical records that are related in any way to treatment for the alleged brain injury, which is alleged to have resulted from exposure due to carbon monoxide, are from the plaintiff's retained experts. Those experts were not, she visited those experts after written discovery, after her deposition was complete. And we've had those experts' reports and records for 163 days as of today. Those records are not going to be sufficient for our experts to give, opinions, Judge. I mean, they really need to have a full examination with a full background on Ms. McClain. And because there are no medical records really at all that cover her background with respect to an exposure to carbon monoxide, we're simply asking that they be allowed to conduct an examination of her so that they can gather evidence upon which to base their opinions.
Okay. All right. And so why is it, if you've had those for now, what is that, 163 days, that's almost half a year, 6 months, why is it taking so long to bring it to this point?
Initially, what we wanted to do, Your Honor, was to mediate the case in light of the significant designation of experts. The plaintiffs have 10 retained experts, and so opposing counsel was agreeable to that. We worked out the details and the dates. I think we had to push it back a time or two, but our hope was to try and settle the case before we encountered the expense of expert discovery. That mediation took place 67 days ago. And in the time since, Your Honor, we've moved very quickly to depose the plaintiff's experts. We've deposed nearly all of them, mostly via Zoom. And all that remains to be done at this point is for our, is to depose the remaining experts and to have our experts deposed. But the problem is our experts can't give full opinions without an examination of Ms. McClain.
All right. Mr. Winthrop?
Your Honor, thank you. May it please the court. My name again is Griff Winthrop. I spent 20 years as an insurance defense lawyer. I started my practice at Long, Weinberg, Ansley, and Wheeler in downtown Atlanta. I now practice in Florida. I'm licensed in both states. The point of this, pointing that out to the court, is to let the court know this is not an unusual case for me. This is pretty much all I do now, is plaintiff side brain damage, carbon monoxide, and traumatic brain injury cases. I was concerned pretty early on in this case when there wasn't a whole lot of activity in seeking to depose my experts after they were disclosed. And there was never a request made for an IME until just before the fact discovery deadline that had been ordered by the court after 5 prior extensions to discovery were entered, almost every one of which were at the request of Mr. Davis, with me just not opposing them initially. Where now I believe this latest one would be the 6th request for extensions to these discovery deadlines. And the simple question I had for Mr. Davis just before the deadline was expiring for fact discovery was, could you please just let me know what it is you want to do? What kind of an examination is it that you want? And I can get dates for that. And why don't we do an OCGA 91135A agreed order so that we can lay out the parameters of the examination that your expert seeks to do, and we'll get this lined up. It wasn't until October 29th of 2021, 60 days before all expert discovery was set to close, that Mr. Davis finally provided me with what he wanted to do in the examination of my client. And it turned out it wasn't a single examination, as he had been requesting, or he had been suggesting he wanted to do for the first 2 occasions he asked for it. And I responded with, just tell me what it is you want to do. It was now down to 3 or up to 3 IMEs of my client, and still had never provided me with a proposed order either way. Again, the first time I found out that he wanted to do 3 IMEs and what the nature of those IMEs were was not until October 29, 2021, months after this court's fact discovery deadline had expired, and only 60 days before I would have been able to complete the depositions within the time permitted by this court of his expert witnesses. And again, that would have included time that we would have needed for my client to have been IME'd over the many hours that Mr. Davis has now requested for this, then reports from his experts, then setting the depositions of those experts. It was impossible. With Thanksgiving and Christmas, I was now bound up and bunched up as a result of the delay in getting this information so that I could provide my client for examination. I do not know why a request was not made for this much earlier in the case, after our experts were disclosed, certainly after our expert, 160 or more pages of expert reports that we produced to Mr. Davis in June of last year. I appreciate that Mr. Davis's original client, original adjuster, the one that was available before he got sick, wanted, at least sounded like he wanted to do mediation before conducting expert discovery, but without getting into the details, mediation was a complete waste of time, Your Honor. And it was after that Mr. Davis decided he wanted to take the depositions of my experts. He could not provide me with whether he wanted to do it by person or by Zoom. We finally got that ironed out much later than that. I did everything I could to provide my experts' depositions to Mr. Davis. And I would point out that Mr. Davis has now canceled the deposition one day before Thanksgiving, the Wednesday before Thanksgiving, canceled the deposition of Dr. Weaver, who is my main medical causation expert, Dr. Lyndall Weaver. And he canceled that the Wednesday, the day before Thanksgiving. His deposition was scheduled for the Tuesday following Thanksgiving. It was to be in person. We were going to be in Salt Lake City to take it, had to cancel flight arrangements and hotel arrangements. And he has now twice canceled the deposition of Dr. Holmberg and has not sought to reschedule either of those depositions. And the deadline for me to have completed his experts' depositions expired on January 1st. And he still has yet to provide me with a single opinion of any of his experts. I understand why he hasn't completed the experts of any of my depositions of my key experts. And he did not request specifically what IMEs he wanted to do of my client until we were well into expert discovery deadlines. It was just before the deadline for him to have completed my experts depositions, 30 days before that, and only 60 days when I would have had an opportunity with Christmas and Thanksgiving and incorporating having to do the IMEs. It was an impossible situation for the plaintiff, Your Honor, for us to comply with this court's order. We are on, I believe, the 5th or 6th order extending these deadlines as requested by Mr. Davis. All of these deadlines are those authored by him. I just simply agreed to them every single time. But these are deadlines that he interposed. They weren't deadlines that this court came up with and said, guys, this is it. This is what he came up with. But I read the court's order to mean what it means, which is this is serious and I'm serious about these deadlines. So for 5 prior times, I agreed to him, Your Honor. I just simply decided enough was enough. I need to get this case to trial. I understand COVID has been a problem for everyone. I'm licensed in 4 states. I practice all over the country with this type of case. I'm one of 4 or 5 lawyers that handle these types of cases. And I'm not saying that to impress the court, just to let the court know this is happening all over the country. I get that. And I appreciate it. And I know the courts are trying very hard to move these cases forward, but this is an old case and I need to get it set for trial, Your Honor. And I cannot entertain or I cannot agree to any further deadline extensions, nor can I agree to an IME that's not giving me the details until just before deadlines expire. And I'd ask the court to deny the motion and set this case for trial.
Okay. Mr. Davis, any response to any of that?
Yes, Your Honor. First of all, there never was any agreement to do some sort of joint order for an IME. And you know, Your Honor, I mean, without getting into detail on all the emails, I mean, every time I've asked, you know, hey, we'll need to do an examination of your client, the response has been, well, I'll need to see an order for the court, which I took to mean you're going to need to go get an order from the court. The reason for 3 examinations is because there are 3 experts. It wouldn't be an independent examination. There were 2 doctors in the room, and you know that's and you know certainly that's a question that they'll get asked in the deposition. You know, were they collaborating or were they acting truly independently? Ms. McClain's experts examined her independently in the same fashion over quite a few days. Your Honor, you know, we really attempted to mediate this case in good faith. I do agree that the mediation was a waste of time, and again, won't get into the details of that. But we've worked as hard as we can since the mediation to move this case forward. This was not an attempt, absolutely not an attempt, to jam the plaintiff's counsel with some dates. I mean, I completely agree. We would need more time to complete this discovery. The fact of the matter is, Your Honor, we're very close. The reason that the deposition of the plaintiff's principal medical expert, I canceled it, was because I was very hopeful that this court is going to allow our doctors to conduct an IME so that we can get the evidence that we need so that I can consult with them prior to taking one of the most important depositions in the case. It wasn't to be disrespectful to anyone. It's simply because I will not be prepared to depose Dr. Weaver fully without being able to consult with my experts, and they cannot be prepared without an opportunity to examine Ms. McClain. They're ready to move forward with those examinations very soon. I have the dates listed in the order. They're available on those dates. And I believe that we could complete discovery in this case in just a few more months, Your Honor.
Your Honor, to put a fine point on it, Mr. Davis actually thought that my suggestion that we do an agreed order for the one IME that he was requesting that he never described until October 29th of last year. If he really felt that that was me suggesting that he seek an order from you by way of motion, his IME motion wasn't filed until December 3rd of 2021. This is well after any opportunity we would have had to conduct the discovery necessary following that and comply with this court's orders. This has been a delay, Your Honor, one after the other, and we really want to get this case tried, and we'd ask the court to deny these motions.
Your Honor, if I may have one more follow-up on that. I'm rather uncomfortable discussing this because I do not know exactly what Dr. Long's medical situation is. And I don't even know that that's something that I could inquire into. I've asked, and she didn't seem very, very willing to talk about it. All that I can say is that I had some difficulties with Dr. Long that precluded me from filing this motion earlier. And it was our intent immediately following the mediation to move all of this forward as quickly as possible. Again, the intent of the mediation was to avoid the expense of expert discovery. Once the mediation fell apart, the intention was to move it forward as quickly as possible. And I do believe, Your Honor, we've done quite a bit in just 67 days, and we can move that fast in the next 60 days as well.
Okay. Well, here's what we're gonna do. I agree with Mr. Winthrop that we need to move this case along. It's one of my older cases, and a case that's now coming up on 4 years old since it's been filed, and we need to move this to trial. The real procedural problem that I have, Mr. Winthrop, with that is that I do have a number of cases that have been prepared for trial for some time and are awaiting their trial date. And that has been pushed back yet again. In Fulton County, we have suspended jury trials for now through January 14th. But that has caused me to reschedule a pretty significant medical malpractice case that was going to take me 2 weeks. And now we're going to have to factor that in, as well as the other. I have a number of other similar cases that are pending that are awaiting trial. And I say that simply to tell you that I don't, from a procedural standpoint, I don't have a good ability to say, hey, I'm going to deny the motion and we're going to go to trial because I don't have the ability to bring this case to trial within the next 2 months. So because of that, I will allow y'all to proceed. I do want y'all to work together, meaning this is Mr. Davis's motion. It's Mr. Davis who has put off the depositions of Weaver, Holmberg, of the IMEs coming in at this time. And so Mr. Davis needs to take the oars in this and prepare orders that are compliant with statute for the court. That I will be happy to sign off on. I also want at the same time for y'all to agree to reasonable timelines for both of you. I know, Mr. Winthrop, you were talking about, and in your motion, you talked about the need to depose these 3 experts. I agree with that. And so I need y'all to come up with reasonable timelines within which the IME will take place, or the dates on which the IMEs will take place. And then after that, in a amended scheduling order, and this will be a final amended scheduling order. Y'all could put that on there. I don't intend to change this again, unless I guess y'all come back to me and agree for some reason, one of your doctors gets sick and can't do those kind of things. I mean, those are things beyond our control, but otherwise, if it's just delay, I'll intend for this to be a final scheduling order, but I want that to include timelines for the depositions, for the reports to be coming out, and those need to be on an expedited basis so that you can move this forward, so that when we are back and we have trial dates that are going to be available, don't expect it's going to be too long. We have been trying cases since April of last year. We can get this on a trial calendar and moving forward. Can you all work together to prepare those orders and get that done?
Yes, Your Honor. Absolutely. And we have Mr. Davis and I, up until the point in time that this became this issue, have worked together.
Okay.
We have a good relationship, I think.
And I understand, Mr. Winthrop, that you've got to be in there's got to be some point where you say, look, we've just got to, we got to move this thing forward. So that's where, and I think this is an appropriate time to do that. I'm sorry, I cut you off, Mr. Winthrop. Go ahead.
It's okay, Your Honor. We do not have, Mr. Davis is seeking an IME from a neuropsychologist. The argument has been that he wanted to match like-kind experts. We do not have a neuropsychologist in our case. So I would ask that the court not allow a neuropsychology examination because that's not something that we've put in as an issue. But the other, if counsel wants to do the other two IMEs and the court is going to even over my objection at this point because of the timeliness of it, we would ask the court to not permit the neuropsychology IME since, again, we don't have a neuropsychologist or a neuropsychologist evaluation. Mr. Davis has been aware of that, obviously, since we disclosed our experts and, of course, since he's gotten the reports. So we would ask the court to at least not permit that and go forward with just the two IMEs that match up with the doctors that we have.
Let me go back. Is the proposed order filed for your neuropsychologist, Mr. Davis?
Yes, it is, Your Honor. And
Which
we
one is that?
disclosed-
When did you do that?
When did I file the motion, Your Honor?
Yes.
That was
For
the
neuro-
first motion for IME, which was December 3rd. A neuropsychologist was designated as an expert, Your Honor, during our expert designation deadline, which I don't have in front of me, but it has been several months. It was Dr. Long previously.
Oh, this is the new doctor that you had to replace? Okay, do you know which exhibit it was with respect to your,
I don't think there's been an order proffered to the court yet, Your Honor. I think Mr. Davis.
I agree. I'm sorry,
Oh.
Your Honor. We did not submit a proposed order.
okay. So then what's I guess what I'm asking, I was going to look at your order, but what's the point if a neuropsychologist is not disclosed by the plaintiff, then what's the point of having a psychological examination?
Well, Your Honor, because Ms. McClain, in some of her older medical records, has a documented history of psychological problems, and it's possible that they could be related to this issue.
Your Honor, psychiatric might be more appropriate of a description of what he's talking about. I think he's talking about depression issues, but that's not neuropsychology. Neuropsychology is evaluating somebody's baseline, and any deviation from the baseline is to cognition. That has not been put into this case at this point through a neuropsychology evaluation. We do have a psychiatrist, and Mr. Davis has a psychiatrist, and we don't have a problem with that examination. That's Dr. Holmberg on our side, and I cannot recall who on Mr. Davis's side, but he has asked for a psychiatric evaluation, which is fine. We have, again, with the exception of my objection for timeliness, it's fine. We have a psychiatrist. He's asked for a neurologic examination. That's fine. We've done a very extensive neurology examination. That's fine. So those two, I'm obviously, we can match those up one for one, but I'm still at a loss as to why there would be a neuropsychological evaluation since we have not put neuropsychology into this case.
Well, let's do it this
Your
way.
Honor.
I think the appropriate way to do this is so that we know what the issues are is for Mr. Davis, as he puts together his order and lays the groundwork or the bases for which he intends to do the examination for the neuropsychologist. And tell me that doctor's name again, the new one, not long. It's
Restack, I think, Your Honor.
Restack is our new, and then it's Dr. Gordon and Dr. Bolt.
right, but Dr. Restack is the one that's at issue. Okay.
That's
Right.
correct.
Okay, so you'll need to put forth the basis upon which you expect the examination and what you expect to have happen. And then Mr. Winthrop, I'll give you an opportunity once you have that. I know you've been asking for that, but that needs to be part of this. Once you have that, then if you have a further objection, you can file that with the court, and I'll just have to make a decision on whether I enter the order or not.
Yes, sir.
And so, because I just don't have enough information right now. That wasn't in your brief, so this is a new issue. So I'd need more info on that before I can make a final decision on that.
With due respect, Your Honor, we did address that briefly in our brief, that there is a neuropsychology evaluation that's being requested, and there is no neuropsychology evaluation on our side.
Understand, but that doesn't really tell me, that could be saying and here's what I don't know. And I'm sorry, I'm just not a doctor. I don't specialize in this kind of medicine. So you're going to have to forgive me, but I've also seen, you could have an orthopedic surgeon, or you have just an orthopedist, and I'm not saying an orthopedic, or you have a psychiatrist and a psychologist. They may do somewhat different things, but they also may be doing the same thing because their specialties overlap. And I just don't know right now without more information. So I would need that from Mr. Davis.
Okay.
And then whatever your objection is as to what you think this neuropsychologist is doing that's inappropriate for an IME in this case. Does that make sense? Okay.
Yes, sir.
Just, yeah. So what I would like though is, I know y'all have already talked about this. Mr. Davis has already been working on this. So I want to see these orders, and I want to see the proposed timeline going forward for everything. If y'all can work together, and I'm going to let Mr. Winthrop tell me, can y'all get that done within a week?
If Mr. Davis gets the proposed orders over to me. The other issue is my client, I have not confirmed with my client the availability and the dates in January that Mr. Davis, I was pointing, I think there's a typo. Mr. Davis has 2021 in the dates. I think he meant 2022.
I saw one that said in 2019, and I was thinking, wait, that's
Yeah.
not, I think it's 2021. So
None of us have a DeLorean time machine at this point, as much as we
right.
but I have not confirmed the availability. Plus, I've got a trial. We think I have a trial starting in around that time frame in Orange County, Florida. So those probably will not be workable. But with Mr. Davis providing me with copies of the proposed orders with the scope and purpose and of what's going to be done, again, I'm pretty familiar with neuropsychology. I'm pretty confident I know what is going to be done. It's a lot of 8 hours or so worth of testing, but written testing mostly. I certainly will provide what my objection will be at that point, which will be very similar to what the court's heard already.
Okay. So let's do this. So Mr. Davis, if you'll get your proposed orders to Mr. Winthrop within 7 days, and then we'll get them when y'all have taken a look and either agreed, or you send us back what you disagree on, and I'll just have to enter what I find is an appropriate order.
Yes, sir.
Certainly, Your Honor. And that would also include a proposed order for the remaining scheduling order. Is that correct?
Correct. Yes, sir.
Okay.
Okay. All right. Unless there's anything else, I'll let y'all go. I hope y'all have a good rest of your day.
Thank you, Your Honor.
Thank you, Your Honor.
Take care and be safe.
Thank you too, sir.
Thank you.